Hey everyone, welcome to a Legal Friday episode of The Bullet. My name is Paul Lathrop. I'm the Deputy Director of New Media for the Second Amendment Foundation. Joining me today, as he does on every Legal Friday, is Alex Ooley of the Ooley Law Offices in Indiana, also part of the O2 Training Group. Alex is both an attorney and a firearms trainer. Alex, thanks for coming on again today, man.
And great to be with you, Paul.
Let's get started. We have a topic we're going to cover today, but I want to get it started with a couple of stories. The first one I want to talk to you about, broke a little bit earlier this week. A federal judge in New York has issued a temporary, a temporary restraining order prohibiting New York from enforcing part of its Concealed Carry Improvement Act, specifically as it relates to carrying in places of worship. Now, this on its face, this looks like a victory, but this is, as it says, is a temporary restraining order. They still got to go through this in court, right?
Yeah, so I think it bears some discussion about the difference between a temporary restraining order and a preliminary injunction, which are essentially the same in that they restrain a party from doing something while the case is pending. In this case, enforcing New York's law that prohibits the carrying of a firearm in a place of worship. A temporary restraining order is different from a preliminary injunction in that it's temporary, whereas a preliminary injunction is somewhat more permanent. And the judge here granted the temporary restraining order because there was a likelihood that the plaintiffs would succeed on the merits of the case once it was fully litigated. There was irreparable harm that an injury would be suffered, and that people couldn't exercise their rights to carry a firearm. And the injury was likely to occur immediately, hence the need for the temporary restraining order now, before the judge could issue a preliminary injunction after a hearing, which my understanding is likely to happen after the hearing on November 3rd.
Okay. So, yeah, and this is not something that's going to take another year to pan out. They've got a hearing scheduled for the 3rd. This should move forward fairly quickly.
Yeah, I think it should. The preliminary injunction is likely to be entered, I believe, after the hearing on November the 3rd. And then I don't think the judge will change his position after that hearing. I'm sure that New York will appeal or explore that opportunity at least.
Sure. The big positive I got out of this is because the judge thinks it's likely that the defendants, which are the SAF is handling part of this, as well as the Firearms Policy Coalition is involved in part of this. But the judge thinks that the people bringing the lawsuit are likely to prevail is why he issued this temporary restraining order. So that's encouraging, at least.
Yeah, and my understanding is that this case was brought by two ministers, two preachers in Western New York, and they, along with other individuals in New York, don't have to suffer the harm of not being able to carry a firearm in a place of worship while the case is pending. So that's great news for residents of New York.
Absolutely. Yeah, and I don't know about New York. I don't go to church in New York, but here where I'm from in South Dakota, several churches have dedicated security teams. And I would imagine that, I would hope that there are some in New York that have that as well. I certainly hope. Go ahead.
Oh, sorry. I was just going to say, I read the brief that the Second Amendment Foundation filed in support of the temporary restraining order. And of course, their argument is based on the analysis that was provided to us in the Bruin decision by the Supreme Court, and that is the text, history, and tradition analysis And one of the things that they noted was that not only is there no historical analog to support the state of New York's restriction on the carrying of firearms in places of worship, in fact, there are some examples of places of worship requiring their parishioners to carry a firearm when they attend church as a way to protect the place of worship. So, in fact, the historical analogs may contradict the New York law.
I would love to see that in modern days. It would cause a lot of people to lose their minds, but I would love to see it. The next story I want to cover today. This hit my radar just honestly an hour before we went to air, and there's a case in Alabama where, and I'm going to go ahead and pull this one up. Excuse me, I'm sorry, not Alabama. It's a Mississippi resident filed a federal lawsuit challenging Alabama state park regulation that requires written permission to carry a firearm into a state park. William Lee Mitchum of Pascagoula has filed a lawsuit on Monday claiming the regulation is an unconstitutional infringement on the Second Amendment. His lawsuit asks the court to issue an injunction to block its enforcement. I've looked all through this story, and I did a Google search for this lawsuit. I could not find where this guy is being represented by an attorney or by the SAF or GOA or Firearms Policy Coalition or anybody. So it appears this guy is going solo on his own. All I got to say is good luck to the man. I don't know enough about the law to know I'm not qualified to do what he's doing.
Yeah, we talked about this a little bit off air, that the person who represents himself has a fool for a client. And I'm not suggesting that this person is a fool, and maybe he is represented. But the problem is that someone who's not been trained in the law and procedure specifically may have a meritorious claim that fails simply because they're not able to navigate the procedural hurdles that you have to navigate to successfully litigate a claim. So I hope that he can find some success. It sounds like he may have a meritorious claim, but I hope he has good legal counsel.
Well, and the danger is you do not want to set a bad precedent. If he's filing in federal court, that means it sets a precedent, and if the court rules against you, that hurts us going down the road.
Yeah, although if his case is thrown out simply for procedural errors, that wouldn't create any sort of substantive precedent in terms of the right to keep and bear arms. So if that's the case, that's one thing. But if he is able to successfully litigate the case procedurally but not make the correct arguments on the merits, that could potentially create bad precedent.
Sure, and I forgot to mention at the beginning of the show, if you're catching us live on the Polite Society podcast feeds, you can comment on the YouTube or Facebook live video, and we'll get your comments and get them up on the air. We'll discuss them live. If you're catching us anywhere else, OpsLens or anywhere that picks us up, go to Twitter and tweet with the hashtag #TheBullet, and we'll get those comments as well. We'll discuss them live. But Alex, the next thing we wanted to talk about, and I hear about this every once in a while. I know you hear about it in your legal classes, and that is using a firearm to defend your property. From every training I've been through, it's you use a firearm to defend your life. Texas notwithstanding, it's not generally looked upon very well if you're shooting at somebody that's trying to steal your car. Cars can be replaced.
Yeah, that's right, Paul. I think that the law in every state, as you said, except Texas, looks at the use of deadly force as a tool of last resort and a tool to protect the life of a human being, that is yourself or another innocent person. And you alluded to the questions that we get in our legal classes. We get this question a lot. Can I use a firearm to protect my vehicle? Can I use a firearm to protect other pieces of property? And the answer is usually no, unless it's an occupied motor vehicle, for instance. But then you're not really protecting the vehicle, you're protecting yourself. And if somebody is trying to steal your occupied motor vehicle, that is evidence that they are likely trying to cause you harm. So that's one example, for instance. But another one that we get is this question about whether people are justified in using deadly force to protect their pets, like their dog, for instance. And again, the law sees pets as property and not human life. So the legislature, and the law could change on this. So the Legislative Assembly in states could come up with a law that says you are justified in using deadly force to protect a pet or an animal. But most states have not said that. And the balance has been done to say that you should only take a human life to protect another human life.
Right. And my understanding, and again, my memory is not the greatest after my medical issues last year, but it's not just to protect a life, it's got to be an innocent life. It's you don't, that's why we don't get involved in altercations. We are not the police, we're not the one who sort these things out. To protect an innocent life is why we use firearms. It's not to, we don't step in to sort things out and find out who's right and who's wrong.
Yeah, I think Masad Ayub provides a useful framework. He talks about the concept of innocence and imminence. Basically, the question is, are you facing an immediate, otherwise unavoidable threat of death or grave bodily harm? And is that threat to you or another innocent person? If the answer to all those elements in that question is yes, then you may be justified in using deadly force. Another person that talks about the elements required to support a claim of self-defense is Andrew Branca. He wrote The Law of Self-Defense, and he talks about 5 different elements that I think provide a useful framework for deciding whether or not a claim of self-defense is a legitimate one. And he talks about the concept of innocence, which you mentioned, imminence, proportionality, avoidance, and reasonableness. And remember, a claim of self-defense is an affirmative defense, and if you're prosecuted for murder or manslaughter or some crime based on your use of deadly force, the state has the burden of proving that you are guilty beyond a reasonable doubt. And if they disprove any element of your self-defense claim will fail, and you could be facing years, if not life, in prison for your use of force. So it's important that you understand when you can use force and how much force you can use.
Yeah, I totally agree, and that I don't mean, especially the bullet. I don't like to turn them into commercials, but both you and I have a close working relationship with the Armed Citizens Legal Defense Network, and I heartily endorse them. There are other companies that do the same thing, but if you carry a gun and your intent is to protect yourself, I strongly advise you to get covered by one of these organizations that does something like that. Simply because Alex doesn't work for free. He can't. No other defense attorney is going to work for free. They've got staff to pay. They're great people, but they've got staff to pay, and lawsuits cost money. Defending people costs money. Places like ACLEN will pay the attorney's fees right off the bat, and depending on where you go, they'll usually pay to bail you out of jail. Again, check with the organization before you pay for your membership. But I believe everybody who does carry should be covered in one way or another. What do you think, Alex?
Yeah, I agree. ACLDN is a great organization. The membership to their organization is useful for not only the membership and the network they have and the fund they have to help provide you with a legal defense, but they also provide great educational resources to make sure that you are educated and that you do know when you can use force, including deadly force. And so that's a huge, I mean, the membership fee is worth it just for the educational materials.
Oh yeah.
But you also get access to potential funding in the event that you are engaged in a self-defense incident, and you get access to a network of attorneys and potential expert witnesses who may be able to testify on your behalf. But it's important to understand that a lot of organizations, including the ACLDN, base their coverage, so to speak, it's not technically insurance, but base their coverage on whether or not they believe your act of self-defense was legitimate. So it's not a get out of jail free card. You still have to be educated. You still have to be well trained. You still have to know when and how much force you can use.
Yes. I want to get a comment in here real quick. Jack from the Facebook side says New York won't allow it. It's murder insurance. Yeah. Well, New Jersey is looking to require, if you want to have a permit, they're looking to require you to have insurance. But I think New Jersey is actually looking for a different type of insurance. But New Jersey a few years ago was trying to run ACLDN and others out of the state as well. It didn't work so well for them, but I'm going to be having, I'm in the next, I believe it's a week from today, we're going to be having Marty Hayes from ACLDN on, and we're going to be talking with him. So we'll get into that then. But I want to talk one more. We still got what, 15 minutes. I want to broach one more topic with you, Alex, and that is this. Maybe I should get to this in a instead of a legal, but in the training Friday episodes. But let's talk about it in legal too. Quite often, I tell people, and as a general rule of thumb, if the bad guy is retreating, it is time to stop shooting. I'm not going to go into the specifics. There is a very limited, here's where my memory fails me. When I went through Masad Ayoub's training course, there are parts of it I'm not allowed to speak about publicly. I don't know if this is that part or not, so I'm not going to specifically speak to it, but and give out exact but there are exceptions to that. And if you want to know what they are, you got to go through a Mag 40 class. So there you go.
Yeah, and we've talked about Mag 40 a number of times on the show, but for people who don't know, Mag 40 is a 40-hour class that is offered by the Masad Ayoub Group. Mm-hmm. 20 hours of it is classroom instruction about the lawful use of force in self-defense. And the other 20 hours is training on the range about how to handle a firearm safely, how to be proficient with a firearm, and how to get shots on target in a defensive situation. So it's a great class. I think it's a great value. I mean, there are lots of great trainers out there, but there are very few people who can mix the firearms training with the legal training so effectively as Masad Ayoub. So I think it's a wonderful class for that reason alone. and he offers the classes all over the country. I think he's primarily doing them in Live Oak, Florida, but he does them all over the country. So if you can find one near you, I definitely encourage you to attend.
Yes, absolutely. I know he's done them not only here in Sioux Falls because I've hosted them. He's done them in Omaha, which is only about 3 hours away. He's done them in central Minnesota before, but not recently. He does get to the center of the country. He did one in Texas. He gets to Texas regularly. Let's put it that way. And up to
But getting
Washington
to,
State.
oh, sorry, I didn't mean to interrupt.
That's all right. Go
Oh,
ahead.
I was just going to say, getting back to your point about uh, somebody who's fleeing. The important point there is that we're not law enforcement, and we're not trying to stop people from committing crimes unless there is an imminent threat to you or another innocent person. But with that said, Masada Ayub does talk about a lot. There's a lot of criticism you always hear in the media of people who call a shooting a good shoot or a bad shoot, and if somebody gets shot in the back, it's almost like that's automatically a bad shoot. Okay, and that's not necessarily true. And Masada Ayub talks about this and why that's not necessarily true, because when you recognize the threat and you recognize that it's a deadly threat and you start uh, firing your gun, your reaction time is such that you may pull the trigger and not realize that it's time to stop once the threat turns its back. So
I
it's possible to shoot a person in the back, but still have been justified in the shooting.
I will say this as a and I say this with authority. As a truck driver for 20 years, I know something about this. I've seen the studies. Normal human reaction time. I'm not talking race car driver. I'm talking normal, untrained human sitting down. Their normal reaction time is 3/4 of a second. A lot can happen in 3/4 of a second. Anticipated reaction time is half a second. So, and even then, there are several things that can happen. Can you twist in under 3/4 of a second? Sure, you can. Yeah. So, anyway, let me get this comment in here real quick. I love this comment from Robert over on the YouTube side. Chuck Norris has a picture of Mass on his wall over his bed. Yeah. Yeah. Mass is not only a friend. I not only consider him a friend, a mentor. He's also a bit of a hero of mine. So I hope when I get to be his age, I'm as active and as sharp as he is. And I've got a ways to go because right now I'm not as sharp as he is.
And if you're not familiar with him and you are interested in taking his class, you might also check out, he spoke at the Gun Rights Policy Conference recently, and I think, Paul, you got his segment pulled out into an individual video on YouTube and maybe on Facebook as well.
Yes. It's
So
up on the Second Amendment Foundation's YouTube channel. I know it may be on the Facebook page, but I know it's on the YouTube channel. Uh, the I started putting them on both, but then Facebook started griping at me, so I switched to going to just to YouTube for the updates to the and yeah, there are 2 times so far at GRPC. Masada, you has spoken that I've got him up on YouTube. Just go to SAF's, and if you're watching us live, you're watching us on Polite Society. Jump over when we're done and go to SAF's page on YouTube, and they should be right up near the top. So, all right.
if it's okay, I'd like to go back to the defensive property for a
Yeah,
minute, if I can, because we were primarily talking about the use of deadly force. But remember, there are lots of other types of force that one can use to protect yourself or your property that are not deadly force. So we talked about Andrew Branca's the five elements that he uses: innocence, imminence, proportionality, avoidance, and reasonableness.
Mm.
So you might use reasonable force, which may include deadly force, but it's not going to include deadly force for the protection of property. So there may still be other reasonable force available. It could be pepper spray. It could be, you know, hand contact. It could be a blunt force object of some sort. But be careful, because blunt force objects can be considered deadly force in some circumstances as well. So just because you can't use deadly force doesn't mean you can't use any force to protect property.
I'm gonna just speaking as Paul Lathrop here. If you own a car, you should have car insurance, and that's what insurance is for. If you have a home, you should have property insurance. That's what property insurance is for. Yell at them, try and stay in a secure area. Let them know the police have been called. Let them know the police are on the way. Don't get into a confrontation physically unless you have to. I hate to sound all namby-pamby, but I want viewers, and I don't think they let us stream YouTube into prison. So
I I know lots of people who have gotten in trouble, not personally know, but know of through reading case law, have gotten in trouble because while they may have been justified in using force, they were not justified in using deadly force. Or if they were, they went too far. Or if they were justified in using deadly force, they talked too much when the police got there. There are lots of potential pitfalls in using deadly force. So I want to emphasize that it can be complicated. Not every situation is the same. We talked about training and education earlier. Another great resource is John Correa over at Active Self-Protection. He does analysis of real-world incidents, usually shootings, but he talks about what happens. He talks about the dynamic. He talks about how the person could have, what they did well, what they could have done better. And it helps to visualize these sorts of situations, because you can never anticipate every potential circumstance or every potential outcome. But to the extent that you can watch what other people do and learn from it, there's a better chance that you'll be able to undertake the task at hand when it does confront you. So I can't emphasize enough the importance of education and training as an effort to be prepared for that potential deadly threat.
one more topic I want to talk about briefly as we come down to the time we have, but I want to touch on this. When I very first started getting involved in self-defense, one of my friends was a deputy sheriff, and that deputy sheriff told me about using force plus one. If somebody's coming at you with bare fists, you can use a you can use a knuckle buster, or you can use a something bigger than that. If they're coming at you with a baseball bat, you can use a 2x4. If they're coming after you with a knife, you can use a gun. Well, the last one's kind of moot because both are deadly weapons. But I learned after that, when I started really getting real training, that that's a police thing. That's not a civilian thing. Civilian, you can use equal force. You don't get to use force plus one. Am I still correct there?
That's correct, and that's actually something else that Masada Ayub talks about, because he has a law enforcement background, and he talks about that sort of continuum of force, and where law enforcement may be justified in using force, but a non-law enforcement individual would not be. And you're correct. I mean, and that goes to the concept of proportionality. You can only use the force necessary to confront the force that you're facing. There's no concept of plus one in non-law enforcement use of force.
Yeah. I'm going to get one more comment in here. We got to get out of here because we are running down to the time we have. But Robert says self-defense insurance is banned right now in New Jersey. Phil Murphy called it murder insurance and banned it through the Insurance Commission. Note, the legislature wants to require it if you carry. We'll be getting into that, I'm sure, either on the weekend bullet because that broke this week, or on further editions next week of the bullet. I don't know how they're going to separate out, USCCA, ACLDN, US Law Shield, and the others from general. General liability insurance is not going to protect you if a gang member decides that car is the one I'm going to carjack and starts breaking your window and trying to pull you out of your car. Your general liability insurance is not going to cover your self-defense situation there. ACLDN, US Law Shield, the others will. I don't know how New Jersey's going to get that straightened out in their law, but that...
Well, several years ago, I was wrong when the Supreme Court decided that they could require us to have health insurance, that they could force us to pay for insurance. Now, I'm not sure that the same analysis applies here because now we have the Bruin test. And I think that this requirement for insurance would burden the fundamental right of exercising your right of self-defense. And as Justice Thomas said, if it burdens the right, then we go through the text, history, and tradition analysis. And I think for New Jersey's requirement for self-defense insurance to hold up, they would have to show that there is some analogous historical tradition of requiring this sort of insurance. And I don't think that they will be able to show that. So I suspect that this sort of requirement would fail when it's challenged in the courts.
Well, and luckily, if Roberts goes the other way and decides it's a tax, we've still got a 5-4 instead. And if Roberts goes the other way, so anyway, Roberts is the one that, by the way, is the reason in my opinion, Roberts is the reason we have Obamacare still. So, although this is about self-defense and Second Amendment stories, not about health insurance. So, I think that's going to do it for us, Alex. Anything you want to plug on the way out the door, man?
Yeah, we as you mentioned at the beginning of the show, I'm an attorney, but I'm also a firearms instructor. We have a 5-hour class about the lawful use of force in self-defense. We've got one coming up here in just a couple weeks. If that's something people are interested in a couple weeks or in the future, you can check out our website at o2gungroup.com. You can also see our legal website at ooleylaw.com if that's something that you're interested in. We do expungements. We help people with appeals of firearms license denials. We also help with general criminal defense and self-defense claims. So check that out. We also have a blog where we write about legal issues going on around the state of Indiana and sometimes on the federal level.
I've got a feeling in the near future, and I've started noticing this, I have a feeling in the near future you're going to be having some 18 to 20-year-old clients that were denied purchases of firearms in Indiana because of the federal government. And I'm hoping that you get some clients. I'm hoping you, on both sides, I hope you don't get any clients because that means the federal government's not doing anything nefarious. But if you do get clients, I'm wishing you the greatest success because that is, I'm starting to get word that 18 to 20-year-olds are getting automatically delayed. And that's not cool. So, alrighty, man. Well, that's going to do it for us and everybody watching, everybody commenting. Thank you. Come join us again tomorrow, Saturday morning Saturday afternoon at noon Central Time. We'll have the weekend edition of the Bullet. We'll talk about the weekend review. Until then, everybody, thanks for watching. We'll see you next time.